Good day, my name is Mark Malloy. I'm an attorney here in Riverside, California. I've got a number of construction and homeowner clients in Coachella that are dealing with mechanics lien issues, so I thought it helpful to give some brief overview on mechanics liens so we can talk about what you're dealing with in your particular situation. The first thing that we want to talk about mechanics liens is we want to find out who you're in contract with and what type of project. If it's a homeowner contractor type situation, then we have to have what's called a work of home improvement contract that complies with the Business and Professions Code. So depending on what side you're on, whether you're a homeowner or a contractor, you want to make sure if you're a contractor that your contract complies with the work of home improvement requirements under the Business and Professions Code. If you're a homeowner looking to contest that contract, you want to find out if that contract is compliant with those code requirements. The next thing we have to look at is if you're not in direct, are you in direct contract with the owner of the property? Whether that's commercial or a home, you want to be in direct contract with the owner. If you are in direct contract with the owner, you don't have to record something called or file something called a 20-day preliminary notice. If you're not in direct contract with the owner, you're a subcontractor on the project or a materialman supplying materials to the project, then you've got to file what's called a 20-day preliminary notice. When I say file, it means you've got to send certified mail return receipt requested within 20 days of your appearance on the project, notification to the owner, the lender, if any, on the project, the general contractor on the project, that you are there supplying materials or working on the job. If you don't do that, then you impact your ability to file a mechanics lien later on. As long as that's filed within 20 days of your first appearance on the project, then you can, of course, proceed with your mechanics lien recording. Even if not sent certified mail return receipt requested right away, you can still file the mechanics lien as long as you file your 20-day preliminary notice. But remember, it's only going to cover 20 days prior to the time that you sent it off by the mail. So if you did a bulk of your work 90 days ago and then you do your 20-day preliminary notice, it's not going to cover all that other work that you did for mechanics lien purposes. So just understand that. The next thing we look at is if you're in direct contract with the owner, you filed your 20-day preliminary notice. What happens if you're not getting paid on the project, or what happens if your contractor files and records a mechanics lien? Well, the next step obviously is recording the mechanics lien. Once the mechanics lien is recorded, you have to file an action to foreclose on the mechanics lien within 90 days. If you don't, then you waive your mechanics lien rights against the property and you cannot go after the owner or foreclose on the mechanics lien. You can go after the owner for breach of contract, but not for purposes of going after the property. If you have a mechanics lien, you want to make sure that you record the mechanics lien within 90 days of your last work on the project. If you don't do that, then you waive your rights to record the mechanics lien as well. So that's another important aspect. The time requirements under mechanics lien law are very strict. They're strictly construed. There's no exceptions really, and so you want to make sure that you follow those time frames carefully and correctly. If you have any questions about a particular situation you're facing, whether a homeowner or a contractor, we do represent both. I'd be happy to sit down with you and discuss your particular situation and facts with you.